welcome back to another episode of I'll Allow It Nevada, your go-to podcast for insightful glimpses into the Nevada judiciary. I'm your host, Seth Easley, representing the Supreme Court of Nevada Administrative Office of the Courts. And today it is my pleasure to welcome Judge Gregory Gordon of the Eighth Judicial District Court, Department C, to the studio. Judge Gordon is joining me to discuss a highly relevant topic to family law, ADKT 0619 and the adoption of rules governing family trials. Judge Gordon, thank you very much for being here today.
It's a pleasure to be here. Thank you.
To kick off this conversation, maybe can you just give us a bit of an overview of what is ADKT 0619?
ADKT 0619, which has now been approved, and it is now the new District Court Rule 27, is an informal trial program to be implemented in family law cases, divorce cases, child custody cases throughout the state.
Okay. So what inspired the need for this?
So when I was appointed to the bench, one of the most surprising adjustments was the overwhelming number of self-represented litigants that were interfacing with family court. It was astonishing to me, coming from private practice, how many cases involve self-represented litigants.
So what is the main difference between an informal trial and a standard trial?
Well, as you can imagine, a self-represented litigant faces tremendous challenges trying to understand the court's rules, procedures, and then trying to comply with them. So when you have an overwhelming number of litigants who are trying to navigate the process and really can't do so effectively, it seemed to many that we needed to maybe think about how the process could be changed or altered to better serve these individuals. And the idea of informal family law trial is exactly what the name suggests. It's a more informal process where some of the technical procedural rules, evidentiary rules are relaxed so that a person without a law degree, a person who's just trying to represent themselves in their divorce case or in their child custody action can better navigate the process on their own.
Okay, so you started going into this a little bit. Are we able to maybe dive in a little bit more on how this does help self-represented litigants in these cases?
Sure. So what we want to do is we want to change the process of a trial a little bit and make it more simplistic in a way that an average person can understand. So for example, in an informal trial, each side has the opportunity to present their case with no objection from or interruption from the other side. They basically get an opportunity to tell the judge everything he or she wants to say in support of their case. The judge would then ask questions of that individual to fill in any sort of gaps. And then once that individual is done presenting their case, then the other side would get their chance. The idea is to sort of relax traditional direct exam, cross-exam type format that a self-represented litigant doesn't really understand, right? Mm-hmm. And then another aspect of it is to relax the rules of evidence, because often self-represented litigants don't understand how to make objections. They don't understand the rules of evidence. So in an informal trial, each side has the opportunity to present whatever evidence, documents, things of that nature to the judge. The judge receives everything, and then the judge decides what weight to give the evidence. Because in a traditional trial, you would have a party offering an exhibit, you'd have the other side maybe lodging an objection, maybe hearsay, or maybe authenticity. Well, these are concepts and terms that self-represented litigants don't understand, right? It's over their head. So we have to find ways to make the process more comprehensible, more understandable, so that when the trial is concluded, people leave feeling like, okay, I had a fair shot. I understood the rules. I was able to talk to the judge without getting interrupted. I was able to tell my side of the story. I was able to show the judge the evidence that I wanted the judge to see. And I can leave here feeling like the process was fair.
What types of family law cases will these informal trials be most used in?
I think that, well, it'll apply in any divorce case. It'll apply in any child custody case. And it'll also apply in what we call post-judgment proceedings. So, for example, maybe there's already a divorce that has occurred or a child custody order in place, and someone is seeking a modification of that. It would apply in those cases as well. And I think it's important to point out, and we can talk about this a little more in detail, but this is an opt-in program. In other words, this isn't forced on anyone. No one is required to agree or to have an informal trial. The traditional trial would apply in all cases unless the parties, both parties, select and opt into this program.
We've touched a little bit already on how informal family trials benefit litigants, but are there any potential difficulties or drawbacks that litigants might have to work through, or not just litigants?
I think that really from all aspects, from the litigant's perspective, there's only advantages. In other words, if you're trying to navigate your divorce or your child custody case without a lawyer, there will only be advantages by having a more relaxed, a more informal process that you can better understand, and you can understand why things are happening the way they're happening in the courtroom. Whereas with a traditional trial, litigants often leave feeling like they didn't understand
what just happened.
And so they leave with a real sense of, was that fair? The judge didn't get to hear what I had to say because there was an objection or there was some procedural, maybe something that stymied him or her that they didn't quite understand. I think that there is, with the informal trial, there's just a real desire to create a process where everyone feels like they got a fair shake,
Absolutely, that makes sense. So a good portion of our listenership are judicial officers and attorneys. Is there any way that they might be impacted by this that they should know about, or just considerations?
For judges, this should be not a difficult adjustment, because I think a lot of judges, when confronted with trials involving two self-represented litigants, judges are already having to find ways to accommodate the litigants. They're already finding that the trials maybe are being conducted slightly different than they would be with two attorneys.
Okay.
And so I think this is really a reflection of how a lot of these trials are already being conducted, in the sense of it doesn't look like a traditional trial because you don't have attorneys involved. You just have two litigants who don't understand a lot of the complicated side of it. So for judges, this should be a little bit of giving some structure, giving some support for what judges are already having to.
Well, they're already kind of doing.
Yes.
Yeah.
For attorneys don't really have a role in an informal trial.
Right.
It's designed for the litigant to present their own case. Attorneys can be involved in a support role. In other words, someone can bring an attorney with them, and the attorney doesn't really participate other than supporting the client, maybe guiding the client behind the scenes. But again, this is an opt-in program. So, these trials will really lend themselves to situations where there are no attorneys involved, which is large majority of our cases.
That's interesting. I didn't necessarily know that. So a large portion of your family trial cases don't involve attorneys.
Yeah, we don't have any sort of real statistics, but the informal sort of numbers that we've sort of come up with is it's somewhere in the 80% range of the number of cases where both sides don't have an attorney.
both sides even. So yeah, that's some really interesting context, the need for this.
Well, and if you think about it, that it is, I call that the sort of changing landscape of family court, because that family court didn't look like this 10 years ago. It's changed dramatically.
Pretty quickly.
Yes. And there's a variety of reasons. There are a lot of reasons why someone may choose to do this without an attorney. Some of it financial, maybe there's language barriers, maybe they're just in a situation where they've never hired an attorney before and don't really feel comfortable doing that. So there's a multitude of reasons why people maybe don't hire a lawyer, but with this large number of cases, with people trying to navigate this process on their own, it didn't take long for me after taking the bench to realize something had to change.
Right. Okay. So what potential long-term impacts do you think this could have in your realm of law?
Yeah. I think this is all about creating trust in the system, right? This is what this is about, because we all know that right now, the public's confidence in the government, whether it's the judicial branch, the executive branch, or the legislative branch, is sort of low.
Yeah,
right?
not great.
Yeah. And I think that there's a sense that courts, especially the family court, has a mission, and that mission is to serve the public, to help people resolve disputes, help children who are caught in this conflict sometimes. And we have to do a better job serving the public to resolve conflict, to resolve cases. And this is all about doing it in a way that's more effective for the people that we serve, and really sort of building back some faith and some trust in the courts and in the system, right?
Absolutely. That's very important.
Yeah. I mean, you can only imagine something as important as a child custody case, right? Where I can't imagine anything more important to an individual than the safety, the welfare, the well-being of their child, right? And here you find yourself in a courthouse, right? And appearing in front of a judge, trying to navigate a process that you know absolutely nothing about. You feel outmatched, right? You feel at times like the system is sort of working against you, right? But at the end of the day, these are real problems. These
highly
are
personal,
highly personal. And if we can't help people get these resolved, if we can't help resolve some of this, people are suffering, right? People are going back they're living in conflict, or there's kids living in conflict. So it's important that we do our job, and it's important that we do it well. And it's important that the public has trust in the job that we're doing.
Hi, everyone. I hope you're enjoying this episode of I'll Allow It Nevada. We're always striving to bring you valuable insights and education, not just to judicial officers, but for anyone interested in the Nevada judiciary. If you find our content helpful or intriguing, please share your experience with your friends, family, and colleagues. Your support helps us reach a broader audience and ensures that more people can benefit from our discussions. Thank you for listening and supporting I'll Allow It Nevada.
So I was mentioning how I wasn't on the bench long and quickly realized that the landscape of the family court had changed, or it was, and that the need to better serve self-represented litigants was apparent. And so I wrote an article initially about it, designed to provoke some thought about how judges manage these situations, right? How a judge's traditional role of just sort of sitting back and listening to both sides present their case and deciding the outcome really didn't work well in a situation where individuals were appearing without attorneys. So I wrote that article to provoke some thought, and in there came this idea of the informal trial model, which is not an idea that I came up with, but rather something that we've adopted from other states. So there's about 7 other states already that have implemented this type of a program.
Okay.
And so I was able to sort of look at those states and sort of draw upon their success to build the program that now Nevada has.
You've mentioned 7 other states have implemented the same program or similar programs. So it's been largely beneficial from what you can tell?
Yeah. I mean, Oregon, for example, I think they implemented the program back in like 2015. So it has a lengthy track record there. And the success has been overwhelming. I mean, I've talked to judges from Oregon. I've gone to other conferences where I've met judges from other states. And every judge I've spoken with who has either where their state has adopted or implemented this type of a program just raves about it and its success.
So does this type of program also help to speed up processes? Not necessarily.
It may do that. I mean, we're going to find that out, right?
Okay.
We're going to see how that goes. I mean, I can speak for the Eighth Judicial District down in Clark County. I mean, we have an overwhelming caseload, right?
Right.
The dockets of our family court are full of cases. And so often it's what is slowing down case times and is just the number of cases. I do think that there are some ways that this can help, because I do think that litigants may be more inclined to ask for this program, ask for the informal trial, and it may help us move more quickly to some type of resolution. So I'm hoping that there will be some improvement in the length of how long these cases are in the system. Mm-hmm. But I think that will be a secondary benefit. I think the primary benefit will just be the way that these individuals feel.
Right. Their confidence in the process.
Yes.
Yeah.
That the family court did its job,
right.
that it served its purpose, that the judge provided a fair process, and that the outcome was fair. And I think that's the primary
benefit.
Yeah.
Okay.
But I do think that, and a lot of judges have in talking with a lot of judges, I am hopeful that this will also maybe have some benefits in moving things along.
Right. So looking ahead, do you think there might be any adjustments that might need to be made?
I think that the challenge will be just getting up and running. In other words, right. Judges are going to have to be active in, we've got to make people aware of the option, right? Mm-hmm. People have to be told that there's this option for an informal trial. So we're working with like the self-help centers throughout the state, and we're going to try to get the word out to individuals. A lot of the responsibility will fall upon the judges at certain points in a case, whether it's an early case conference or a first hearing, to help educate individuals about this option. Mm-hmm. And then explaining to them the differences between the traditional trial and the informal trial, making sure that they understand the differences so that if they select the informal trial, they're making an informed decision to do that. I think it'll take a little bit of time for judges to get comfortable with that,
right,
and to really be able to implement it in their courtrooms. But, again, this is a program that is working in 7 other states. We've not had to reinvent the wheel here. We've not had to create anything new. So the program has proven to be a success in the other states. So I think it's just going to be getting it up and running, getting in the routine of it all, right? Mm-hmm. So that, and getting the word out about it.
So that's particularly good information for our judicial officers who are listening. Do you have any advice for judges listening who want to be more educated on this, on informal trials?
Yeah, we're working with the AOC to develop some judicial education surrounding this. I actually have a tremendous amount of confidence and faith in my colleagues throughout the state. This is not a complicated program. Right. It is a program designed for people without law degrees and without legal training or background. Mm-hmm. What I always say is the rules of the program fit on 3 pages.
Okay, yeah.
Right? So and so anyone can read the 3 pages of rules and understand completely how this trial is going to be conducted. So I have a tremendous amount of confidence that our judges, our district court judges throughout the state, are going to hit the ground running with this program. I think it's going to make sense to them. I think it's going to be easy for them to implement, right? And I think once we get going, and each judge gets a couple of these under their belt or his or her belt, we're going to really see the success.
Nice. So as a judge who deals with family law cases, what excites you the most about this adoption?
No, it's a great question. And I can, let me try to explain it this way. When you're conducting a trial with 2 self-represented litigants, you can just sort of see on their faces the sense of, I don't understand what's going on. Right? You can just see in their faces the sense of, I'm over my head and I'm scared about that. Mm-hmm. And the stakes are high, right? And when you see that on people's faces, that it's hard. It's heartbreaking, right? Because they're pouring everything out there. The stakes are high, as I've said, and you can just see in their face that they almost feel defeated sometimes before it even begins, because they just feel outmatched by the courtroom,
right?
A judge who's talking language and saying terms that they don't understand, right? There's people in the courtroom, they don't understand their jobs, the clerk, things like that. So they just, and when you see that on people's faces, it's heartbreaking.
Right.
And so what I'm so excited about, and what for me is so exciting, is that we're going to change that, right? We're going to take that feeling away, mm-hmm. and we're going to empower people to feel like they can navigate this process
more confidently
in a way that they can feel better about, even if the outcome's not the outcome they wanted, even if it doesn't go their way. I can't wait to see the expressions and get a sense of them feeling better about the process.
And feeling like they had a fair shot. Like, that's great. So yeah, I've built a lot of confidence in the process. And it's amazing that the judiciary is taking steps towards that, just meeting people where they're at.
Listen, this is not easy, right? I mean, our courts, our rules, this is built on tradition. Mm-hmm. This is built on history. This is built on notions of due process and fair play. There's precedent. There are rules that have been in place for decades. Right? And those things don't change, but society does. Right? The landscape, I keep saying the landscape of family court has changed. We have to evolve, mm-hmm. but this is not an institution that, this is tough work sometimes.
Right. So before we close out this conversation, is there anything else you wanted to add?
No, I'm like I said, I'm just really optimistic. I'm so excited and pleased that the Supreme Court saw the value in this program. The Access to Justice Commission was a big supporter. The Legal Aid Center down in Southern Nevada, a big supporter. So we've had resounding support from our community partners and from the courts. I've said this before, and I'll say it again. This is going to be a game changer for self-represented litigants throughout our state.
Right.
And I'm excited to see where it goes. And I'll be happy to come back in 5 years and we'll just be acting like this has been the way we've been doing it for years, right?
Well, I appreciate you coming in and speaking on this. It is really exciting to hear about the impact that this is going to have on the people of Nevada and the judiciary as a whole. It's been amazing to hear about, and I think very valuable information for our listeners, judicial officers or otherwise. So yeah, thank you very much for taking the time and coming and speaking with us.
Thank you, Seth.
Before we wrap up this episode, we're excited to share some bonus content from the 2024 Nevada Specialty Court Conference. My colleague Regina is here to share some insights and takeaways she gathered during the event.
Thank you, Seth. I was really honored to attend the event and hear not only from the presenters, but also from the attendees. I spoke with a few participants. Here's what they had to say. Before the conference began, I spoke with Angela Lash from the Eighth Judicial District Court, who shared a little bit about her work in specialty courts and some of the issues that can be addressed through specialty court programs.
I think we need more housing options for individuals with challenging backgrounds, both more alternative housing from transitional living to supportive housing services. In addition to that, having more resources that allow them to have more independent housing despite their challenging backgrounds that sometimes prohibit them from being able to move into their own apartments and things like that. And also more services for people who have a mental health diagnosis. And if their primary is mental health, or maybe even co-occurring, just having more treatment options to work with individuals to address their mental health diagnosis.
After day one of the conference, I spoke with Judge Randall Soderquist from the Elko Justice Court. He shared some of his takeaways from Dr. Melissa's session on emerging trends and issues in drug-impaired driving and toxicology.
So it was really interesting to watch Dr. Piasecki because I often review her evaluations that she does for us, but I've never actually had a chance to see her present, and I am just blown away. So the next time I get an evaluation from her, now I'll be able to put a face to the name, and I'm really just struck by how much she knows and how much she was able to convey to us at a level that we could understand her.
I also got the opportunity to speak with Judge Scott Freeman from the Second Judicial District Court. He talked about his involvement in one of our state's drug courts and shared his insights from the conference.
My takeaway that is very important. I've been at a lot of national conferences, and what this conference does is Nevada-centric for all us that practice in Nevada, work in the courts in Nevada, which is very, very helpful. We can network with our colleagues throughout the state of Nevada. It being local, I think, is more important than national. And I found that the expertise of Dr. Piasecki today talking about how drugs work on the brain, very, very interesting. One of the most significant takeaways I got was the fact that when somebody is a long-time drug user, it doesn't disappear. They actually have brain damage as a result. It takes a lot of recovery to get those brain cells back working where they should. I didn't know that, and that was very good.
Judge Jasmine Lilly Spells from the Eighth Judicial District Court shared her takeaways and the importance of measuring metrics of the performance of specialty court programs. She also talked about the importance of specialty courts in our communities.
So thus far we've had two presenters, and I think they've both been amazing. From the first one, it was really important to hear the studies and really what the research is showing. I think that while we all think we're doing a good job, it's so essential to ensure that we have those measures and those metrics to actually measure our programs to see how effective it is for the participants. She talked a little bit about that, gave us some resources and some tools so that we can look into ensuring that we're testing both the team and looking at how we're best serving the clients and the participants. And so that was the main sense to hear from. I'm going to get with my team. We've been working on some additional training. I think it'd be instrumental to do the implicit bias training to ensure that we are treating all of our participants fairly and adequately and that we're getting the same thing out of the program. Additionally, I think the trending information with regard to toxicology really just informs how we are treating particular drug tests. And one of the things that she said was in one of the studies, they saw actually people having more of a negative effect and being unable to complete very basic tasks within the first 3 to 6 months. So we might be looking at that data to transition and modify the requirements that are set forth early on. We might change that timeline to ensure that we're not overburdening individuals who just really don't have the capacity to complete the requirements, and then they're being unfairly punished for something that they're not physically or mentally capable of at the time point. There is a significant need for specialty courts. Oftentimes when litigants come before me or when people of the community think about specialty courts, they think about someone with the initial time that they're in trouble, right? So maybe a first arrest or a first conviction, we should be giving those people help. But if you look at the data around specialty courts, majority of the specialty courts should be treating high risk and high needs, and that's inconsistent with what most people think of. So it is the individual who has failed probation multiple times. It is the individual who has multiple convictions, and oftentimes with those individuals, we're only looking at punishment as a model instead of looking that punishment hasn't worked and everything that we have tried up until that point hasn't worked, and specialty courts have a very high success rate. And so I think educating the public, educating team members, additional judges, litigants as to what best practices says as to who we should be servicing is absolutely instrumental in ensuring that we're meeting those best trends and that we're serving the population that most needs it.
On the second day, I spoke with Judge Michael Montero at the Sixth Judicial District Court about the importance of the Nevada Specialty Courts Conference.
We get to bring together a team that we work with in our specialty courts program, and then we get to engage with other teams, both judges and other team members from across the state. And I think that's, for me, the greatest thing about this conference is the ability to have that interaction with other judges and other team members from all across the state of Nevada. I think the fact that we get to have this interaction with people who work in special cases from across the state is extremely important, especially for a judge in a very, very rural area where I have no other judge to compare notes with, and that's my team alone. And here I get the opportunity to interact with so many different team members and judges that do so many different things.
A heartfelt appreciation to our guest and to everyone who's tuned in to this episode. Before we wrap up, here are a couple of quick important reminders. For continuing legal education credit, be sure to complete a certificate of attendance and email it to jepodcast@nvcourts.nv.gov. If you have any questions, topic suggestions, or comments, we welcome your input. Please email them to jepodcast@nvcourts.nv.gov. We value and look forward to hearing from our listeners. Stay tuned for more episodes of I'll Allow It Nevada, released bi-monthly. This is Seth Easley signing off. Take care, Nevada.